Anirudh?
Yes, good morning.
Good morning, Anirudh. Welcome.
Yeah, thank you.
Though we have been talking a lot upon the phone, but formally we are meeting on the virtual platform. Before we start, the fact that the large number of participants are there, it shows a lot of excitement. A subject which is totally new and fresh, and large number of people would be feeling that it will be a subject to come in forth. As we all know that we are facing the pandemic because of the coronavirus. Coronavirus would be akin to, because it's being transmitted, I am reminded from the mythological theory that there was a demon named as Rakta Bij. And Rakta Bij was assimilated with the fact that whenever the blood drops would fall, another demon would be created. It was only because of the intervention of goddess Kali that it was done. So we all hope that some solution has come and we can go back to the professional nitty-gritty. Meanwhile, I would just ask you to take over the entire show. And just to let everyone know that the format is that in case any question is required to be asked, he has to put it on the chat box. And in case he wants to ask the question directly, then he has to put a question in the chat box that he should be allowed to be unmuted. Meanwhile, nobody could be asked, even though in case the mic is not muted, he has to mute himself so that there is no disturbance and we can go ahead. So over to you, Krishnan.
Thank you so much, Mr. Vikas, for inviting me and providing me this wonderful platform to address so many lawyers and legal officers. It's a great pleasure to be here. As you said today, the hot topic is COVID-19, and COVID-19 is affecting our lives in a manner that I don't think anybody could have imagined. So on the legal front, one issue that has been constantly coming up is what happens to contractual bargains. When we entered into the contract, we did not expect anything of this kind. This is unprecedented. Would this in any manner alter the contractual bargains? In this context, the topic of frustration and force majeure becomes relevant, and it's important to understand the difference between the two and the various ways in which we can question the commonly understood positions of law. Let me start off by going back a few hundred years to see how common law evolved. Because this evolution of common law would be common to both frustration and force majeure, but the effects of the two concepts are very different. You go back to Jane's case in the 1700s in England, where the common understanding at that point of time was that contracts are absolute in nature. Therefore, you either perform or you breach. There is nothing in between. This was laid down in as many words, but as time went by, common law needed to evolve because judges found that in a number of situations, it may not be fair to apply this absolute contract theory. Therefore, a number of exceptions evolved under common law. The first exception to evolve was the implied term exception, which was evolved in the case of Taylor versus Caldwell. What I will do is I will just name the cases now, but I will later circulate a list of citations to Mr. Vikas, so we don't spend time in me dictating citations. He can then circulate it to everybody who's interested. So the Taylor versus Caldwell exception was the first of a kind at that point of time and was on the basis of an implied term. So what had happened in that case was that the parties had entered into an agreement for letting out a music hall on a particular date. But before that date, there was a fire and the music hall was destroyed. The argument then was that based on the earlier rule, if the music hall is not available, it's an absolute obligation and therefore you must pay me damages for it not being available. The English courts evolved this implied term theory to say that the entire contractual obligations are based on the assumption that the music hall is in fact usable on that date. Therefore, you must read in an implied term that in case the music hall is not usable on the said date, then the contractual obligation would no longer hold good. This was the first exception that was carved out, namely the implied term exception. Over time, you had other exceptions evolve under common law. The second exception to evolve was on the basis of a theory called the disappearance of foundation of the contract theory. This evolved in the case of W.J. Tatum Limited versus Gamboa. What had happened in this case was that the plaintiff had chartered its ship to the defendant for the purpose of evacuating civil population of a country. The date of evacuation was supposed to be from 1st July 1937. What had happened was that in the meantime, the ship was seized and released much after the date of performance. July 1st was the performance. The ship was seized and released only on 7th of September. Therefore, in this case, the ship itself, which formed the foundation of the contract, because the contract was for evacuating people using the ship, therefore the ship formed the foundation of the contract. That foundation of the contract had disappeared, and hence the English courts held that the absolute contract theory should not be applied in this case. A third exception was later evolved, called the just and equitable result theory. This exception evolved in the case of British Movie Towns LD versus London and District Cinemas LD. So what had happened in this case was that the parties had entered into an agreement to supply their newsreels to the exhibitors for using it in theaters. Subsequently, what had happened was that as a measure during the Second World War, the Cinematograph Film Control Order 1943 was passed, which prohibited any person to supply or acquire any film rights without the permission of the Board of Trade. Once this order came to be passed, the parties entered into a supplemental agreement saying that once the war is over, then this contract would revive. Because they assumed that this was a wartime measure and that once the war was over, the order passed under the Cinematograph Film Control Order would come to an end. But contrary to what they expected, even after the war, the order continued. The issue then was what happens to contractual obligations. In this case, the English courts read in equity. They brought in a theory called the just and equitable result theory and said that this is directly contrary to what the parties expected. Therefore, we must hold in such a scenario that it is not just and equitable to enforce the contract. This was a third exception that evolved. There's a fourth exception as well, a more recent exception called the radical change of obligation theory. So in this case, what had happened was, this is a 1956 case in England. So the parties had entered into a contract for construction of certain houses within a period of 8 months. Due to the lack of labor being available, this became impossible, and an 8-month contract took 22 months. The argument was that the absolute contract theory should apply. The contra argument was that this rule is not fixed in law, and that when there is a radical change in obligation of the contract, you cannot apply the absolute contract theory. The English courts accepted this exception based on radical change of obligation, but while applying it to the facts of the case, held that this is not an event that parties could not have foreseen. When you look at labor, and the parties are expected in a contract for construction to look into the sufficiency of labor, and in the event of proving some exceptional circumstance which greatly impacted the bargain, perhaps like COVID-19, we'll come to some examples. You can't apply this theory of radical change in obligations. But in effect, this theory was recognized, and as you would see, on an ad hoc basis, common law evolved exceptions to the absolute contract rule, and this is how the law in relation to frustration developed. Ultimately, the position in England was that this is based on construction of the contract. Is this something that the parties could have expected or not? If it was something that the parties could not have been reasonably expected to expect, then in such a scenario, the doctrine of frustration would be attracted. But the law, as you would see, developed on an ad hoc basis, and this provided for a lot of uncertainty, because people in common law jurisdictions did not know what exception would be evolved at what point of time and how to apply the law. Therefore, what happened? As a consequence of all this uncertainty, parties started to contractually depart from this absolute contracts rule. Right? So if you provide in your contract that the contract is not absolute, and that you provide contractual exceptions to performance, then you can't be bound. Because the basic premise of contract law is that you must respect the bargain of the parties. Parties have a freedom to contract, and except for certain recognized exceptions, such as it being contrary to public policy, being forbidden by law, against morality, etc., such a contract would have to be respected. Therefore, what happened was that parties started including clauses which were essentially risk allocation clauses. You would have come across a number of these clauses. For instance, there is a reasonable endeavors clause. I can give you examples of such a clause from an arbitration that I had handled. So there's a investment by a foreign company into an Indian company. There is an exit mechanism provided in the contract by which the foreign investor can exit in a period of 3 years. But in the meantime, it is provided that the Indian party, that is the main company in which investment is made, must take reasonable endeavors to go in for an IPO. The term used is reasonable endeavors. It is not an absolute obligation. So the issue was, well, and there was a formula provided. If they go in for an IPO, this is how the exit value must be calculated. If they don't go in for an IPO, this is how the exit value must be calculated. So the argument was that they could have gone in for an IPO, but they did not go in for an IPO, and that therefore they have breached their obligation. The counter argument is ultimately rejected, but it is a very good argument nonetheless, is that this is only a reasonable endeavors clause. Therefore, if we can show that we have taken reasonable endeavors to go in for an IPO, but we still did not go in for an IPO, then you can't claim that there is a breach. And the argument in that specific case was that what came in between was the 2008 global recession. Consequently, no reasonable party would have actually gone in for an IPO during that period, and therefore there is no breach of a reasonable endeavors clause. The point I'm making is that as a response to the uncertainties of common law, parties started thinking about contractually reading in exceptions to this absolute contracts theory. So you would see a lot of other clauses, such as a best endeavors clause. You may have multiple variants. After all, it's for parties to put down what they want in paper, and so long as it's not contrary in India to the Contract Act, that's all right. One such risk allocation clause is the force majeure clause. Force majeure clause is not a statutory provision by which parties are absolved. It's a contractual provision by which parties agree that for a certain period of time, neither party will claim damages against each other if the cause for the loss is a force majeure event. What is a force majeure event? See, the word force majeure is a French term that is derived from a Latin term, namely vis major, which is a doctrine that is used in tort law. In tort law, vis major is a doctrine that is commonly available, because obviously in tort law there is no contract between the parties. So, for instance, if there is an act that has caused the loss, but that act is an act of God, literally it means an act of God. If you can show that it is beyond the reasonable contemplation of the parties, then there will be no tortious liability. In tort law, it's an absolute defense. In contract law, there has to be a force majeure clause that is incorporated. Otherwise, you can't claim that an act is force majeure. Why? Because essentially, in force majeure is only a risk allocation clause, nothing more, nothing less. The force, though it is a risk allocation clause, in terms of the Indian Contract Act, there is some recognition implicitly by virtue of Section 32 of the Contract Act. Let me read out Section 32. Enforcement of contracts contingent on an event happening. Contingent contracts to do or not to do anything, if an uncertain future event happens, cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contract. Therefore, the first portion of Section 32 recognizes that you may have a contingent contract where you say, I will enforce my rights if this uncertain event does not happen. The uncertain event could be a force majeure event. There is implicit statutory recognition, but if it is a contractual risk allocation mechanism, frankly, even if Section 32 was not there, you could still have had a force majeure clause. Let me read out a few typical force majeure clauses, so you get an idea as to how these clauses read. Just give me 1 minute, I'm just opening. Yes. So let us look at a force majeure clause in certain different kinds of agreements. Let me read out a force majeure clause in a infrastructure contract. This is the force majeure clause in the general conditions of contract for the railways. If at any time during the continuance of this contract, the performance in whole or in part by either party of any obligation under this contract shall be prevented or delayed by reasons of any war, hostility, acts of public enemy, civil commotion, sabotage, serious loss or damage by fire, explosions, epidemics, strikes, lockouts or acts of God, provided notice of the happening of any such event is given by either party to the other within 15 days from the date of occurrence thereof, neither party shall by reason of such event be entitled to terminate this contract, nor shall either party have any claim for damages against the other in respect of such non-performance of the delay in performance, and works under the contract shall be resumed as soon as practicable after such event has come to an end or ceased to exist, and decision of the engineer as to whether the works have been so resumed or not shall be final. So that's a typical force majeure clause in a construction and infrastructure contract. You would note that this specifically refers to epidemic. There are a lot of other contracts that do not refer specifically to epidemic, but will have more general terminology. Like for instance, the contracts of Steel Authority of India specifically use the term quarantine measures. But you look at the FIDIC contract, there is neither any mention of quarantine measures or of epidemic, but you have a general test set out. There is a 4-step test that is set out. If you apply the 4-step test, a pandemic like COVID-19 would certainly fall under that. You have other kinds of force majeure clauses as well. In a power purchase agreement, usually a force majeure clause is even more detailed. So in a power purchase agreement, you would have usually 2 different categories. There are non-political events. There are the 3 categories. Non-political events that would include acts of God like storm, flood, drought, etc. There would be indirect political events such as acts of war, sabotage, terrorism, radioactive contamination. It can be really wide. Then you can have, they also have direct political events such as government agencies or discoms, unlawful or discriminatory delay. Therefore, they also provide, usually the difference in a power purchase agreement is that there are acts that are related to the state discom that are also provided. So today, what is crucial to remember, I'm not going to bore you by reading multiple force majeure clauses, but it is up to the parties to look at how narrow or how wide they want to make their force majeure clause. Usually, most force majeure clauses would cover the current kind of scenario in contracts for power as well as contracts for in the infrastructure and construction sector. There is a slight departure in the context of lease agreements. I will deal with that separately in the end, because lease agreements very often refer to the property becoming unusable as a result of the force majeure event. Right? I will deal with that. So today, what are the common force majeure events? What are the consequences of these force majeure, of the current COVID-19 scenario? So, for instance, owing to the lockdown, it may be possible to argue that it was impossible for a sale of goods contract. Let's assume that there's a contract for periodic supply of certain goods from abroad. Right? So every month there's a contract by which every month certain quantity of, say, coal is to be supplied from, let's say, Australia. All right. Now, today it may be possible to argue that this performance became impossible. I am not certain whether supply of coal has been brought in within essential conditions and therefore is permissible. But if you can show that it is non-essential, then in a COVID-19, it is possible to argue that because of COVID-19, it became impossible to actually import these goods from abroad, and consequently it would be a force majeure event. In the context of a construction contract, you may have a scenario where you can show that independent of, even prior to the lockdown, that a lot of migrant labor started going back. Therefore, it became impossible to form. But you will have to prove this. And post-lockdown, it's obviously much easier, though now with relaxation in certain states, the position is slightly different. Therefore, what is very crucial to show is this causal link. You will have to show, firstly, that based on the terms of the force majeure clause, the force majeure clause is attracted. Secondly, that it is this force majeure event that has caused disruption to the contract or delay to the contract. If you don't show either of the two, you can't claim the benefit of a force majeure clause. Just one clarification. I see some questions on the screen. Do I answer it now or do I answer it in the end?
Anirudh, since you are the keynote speaker, only as on right now, only one question has come.
Okay, can I answer it in the end? Can I take all questions?
It's your baby. You have to handle it.
All right.
There are two modules. One would be that you read the questions and we can answer it right now. But what we have experienced in this process is that sometimes the entire tempo of the entire subject goes away, and sometimes we lose. A few parts have been covered, but the other parts are not covered. So, in the fitness of things, last half an hour we will have a Q&A session.
Yes, I will take it in the end because some of these questions I'll be covering later. They're already.
That's what I'm saying. Then it will break the entire tempo. Let's go the way it's going on.
Sure. So therefore, what is very crucial to establish is this two-step test. One, that you come within the terms of the force majeure clause. And in this context, please keep one thing in mind. The Indian Supreme Court in Energy Watchdog has held that a force majeure clause must be narrowly construed because it's an exception to performance. An exception is always to be narrowly construed. Therefore, a force majeure clause is to be narrowly construed. Therefore, keeping this in mind, you must first interpret the clause to see whether the event falls within that. In a lot of cases, I would believe that certainly the lockdown and most cases even COVID-19 would fall within it. In the second very crucial aspect is, if you fall within it, is this the causal basis for the loss? Right? Now, what do you mean by causal basis? The best example that I can give for this is the English judgment in Classic Maritime's case. So what had happened in Classic Maritime is that there was a contract to ship certain iron ore pellets. The party who had to ship was not in a position to ship. In other words, there was a breach by that party. But at the same time, there was a dam in that area that had burst, which also made it impossible to shift. The argument made was that today there is a force majeure event, the dam has burst, therefore I must be absolved of liability. There was a force majeure clause in the contract which was applicable. But the English courts took the view that the real cause for the loss was the inability of that party, and that a party who has breached or a party which is not able to show that it is otherwise capable to perform cannot take the benefit of a force majeure clause. Right? So, therefore, in Classic Maritime's case, despite the fact that the dam had burst, a party who was in breach was held liable because it was held that the cause of the loss is the inability of the party and not the dam bursting. Right? This is the first crucial causal link test. Namely, what is the real cause of loss? Let me explain with an example in the COVID-19 situation. So let us take the case of a construction contract where the employer was supposed to hand over the site in February. The employer had not even started land acquisition proceedings to acquire the land from the farmers, where ultimately the construction was to come up. In March, you had this COVID-19 outbreak. March 21st, you had the lockdown. The employer then says, this is a force majeure event. I should not be liable because I could not have done anything during this period. But the real cause for the delay in the present case is the fact that the employer had not handed over the site to the contractor. In such a situation, when you do the causal link test, the cause for the delay and the consequent loss is not the force majeure event, but the original breach of the employer. In such a scenario, the employer will be held liable and cannot get away because he would fail the causal link test. The second aspect of this causal link test is explained in this case called Lebeaupin, Lebeaupin. It's an English judgment again. Lebeaupin versus Richard Crispin. So here there was a contract to supply tinned fish, salmon, in boxes of certain sizes. There were two separate contracts. There was a breach in relation to both, because what had happened was that insofar as the first contract was concerned, the tin manufacturer had supplied a defective tin. By the time the correct tin arrived, there was a delay, and the river had run out of salmon, that fish that needed to be caught and tinned. Therefore, the argument was that because the river has run out of salmon, we can't supply, and therefore there is no, it's a force majeure event. The courts held in relation to this that there is the real cause is not the river running out of salmon, but the fact that the person who had to tin the fish first went and procured defective tins. That's a breach. His obligation included getting proper tins and then tinning the fish. On the first day, if the correct tins were available, he could have performed. Therefore, the real cause for the loss is the fact that he did not have the correct tins, and he could go and sue the person who was supposed to supply the correct tin to him. That is between him and that supplier. But force majeure would not be attracted. In relation to the second contract, what had happened was he had some larger tins which were rusting. So what he thought he would do was he would first fill up these larger tins and then come to the correct tins, because he didn't want those tins to go waste. But by the time he filled up the larger tins, the river ran out of the fish. Again, it was held that this was a misjudgment by him. Therefore, the real cause for the loss was his misjudgment, not the fact that the river had run out of salmon. Both of these raise a very important issue. If the subsequent force majeure event arises because of an initial breach, then a party cannot claim the benefit of a force majeure event. Let me give you an example. The examples that I'm giving, a lot of them are going to be in the context of construction for force majeure, because in the context of a contract for sale of goods, it would be frustration that would apply and not force majeure. So when I deal with frustration, I'll be giving a lot more examples in the context of sale of goods. Now, let us take an example where a project is to be finished by February 2020. Because of the employer's delays, the project gets pushed by 3 months. Let's assume that the employer did not hand over drawings in time. Let's assume that the employer delayed in handing over the site, that there were holds, all the standard delays that come up in a construction contract. In such a scenario, the contractor would not have been forced into this COVID-19 scenario but for the employer's breaches. In other words, had the employer performed, the contractor would have finished the project and moved out by February. But the contractor was forced to stay on in March only because the employer initially breached. In such a scenario, the employer would be held liable for the losses during the COVID-19 scenario because the contractor was forced to suffer these losses only because of the employer's initial breach. Right? So there are two causal tests that you need to keep in mind. I'm repeating this because it's a very crucial aspect which is very often lost. People just say, oh, it's a force majeure, neither party can claim. But these two aspects are going to be repeatedly litigated going forward because there are going to be multiple cases where claims can still be made even though it's a force majeure event. The two tests are, and I repeat, first, where the real cause for the loss is the other party's breach and not the force majeure event. That is, the force majeure event is in addition to the other party's breach. In such a scenario, the other party cannot get away from its breach. The second limb of the causal test is where the force majeure causes loss, but the other party is forced to face this loss because of an initial breach of the other party. Right? In the latter case, the loss caused due to COVID-19 is a consequential loss owing to the initial breach. In the example that I gave, the breach of not handing over drawings, not handing over land. The loss that is suffered during COVID-19 is a consequential loss. There are other aspects. Is it too remote? Will Section 73 be attracted? Is there any limitation of liability clause? All of these are a lecture by themselves. Right? But, what I will do is I'll share. We've been writing a series of articles on bar and bench, analyzing a number of these aspects. We've also analyzed Section 73. So I can have that. I can share that with Mr. Vikas and he can circulate it to all of you.
You can post it on my WhatsApp, Krishnan, and I will post it on my groups. People can just enrich ourselves. Though we have been following you on the bar and bench, that is why we caught up on you that you should come and speak.
Okay.
The fact that large number of people are there, it shows that people are actually following you in the other social websites.
That's nice to know. Yeah. So these are we're now coming. There are therefore two crucial causal tests that I mentioned. The second aspect, because these are all exceptions to the common notion that you cannot claim in a force majeure. The second is, since force majeure is only a risk allocation clause, is there any other risk allocation clause in the contract? So, for instance, you may fall under force majeure, but you may also fall under another clause such as a change in law clause. So, there are some contracts. I've seen a lot of power purchase agreements that have this. Some construction contracts also have it, which say that if there is a change in law, one of the parties that suffers due to the change in law can claim compensation from the other. So in such a scenario, even if it is a force majeure event, loss does not lie where it falls. You will have to harmoniously construe the clauses to see, is there any other clause in the contract under which you can make a claim? Right? So a change in law clause is something that is quite common. So how would you apply this to COVID-19? You will say that, well, the lockdown is under a legislation, the Disaster Management Act. Therefore, originally I could work 6 days a week or 7 days a week as the case may be. Regulations permitted me to do so. Now for a period of 21 days or how many ever days, I cannot work. That is because of a change in law. Consequently, I'm entitled to compensation. Because obviously there is a loss of productivity that is caused. if you cannot work during this period, yet you need to keep paying your laborers, you need to keep paying your other subcontractors. Therefore, one clause that I can think of that may be attracted as a change in law clause. You may, in some rare situations, also be able to look at a suspension clause. Usually, suspension has to be by the engineer or chief engineer at site in a construction contract, or by a specified authority in the context of a power purchase agreement. In some situations, following the lockdown, I know that instructions have been issued by that authority. You could then treat that to be a suspension, but obviously everything turns on the wording of the clause. It's not possible to tell you in black and white that this can be done or this cannot be done, but you will have to harmoniously construe all these clauses to see in the context of that specific contract, can you make a claim or not? Right? Therefore, the two crucial aspects is causal test and harmonious construction with other clauses.
Just a minute.
Yeah.
Since the session is 12:30, we have got 12 questions. Just moderate in that way. We can have a second session with.
Yes. Oh, sorry. Hello.
Yeah. I'm saying the session is till 12:30.
Okay.
14 questions on the chat box. I'm saying you can moderate this thing. It's lovely hearing you. I didn't want to interrupt you. But since the session is for 12:30, we will like to have you second time on the board.
Yeah, so now till 12, shall I continue with my talk and then we answer questions after that?
You can pace your innings in that way so that we can also question answers. It's not that we will complete it at 12:30 itself. We can go, but you just pace your innings in that way.
Yeah, sure.
Yeah. So it's wonderful hearing you. I didn't want to interrupt you. But
no issues at all. Thank you very much.
Lest we complete our talk and then they said we have not been able to we were not able to get the answers to our questions.
We'll ensure that there's enough time for the question and answer.
Yeah. That's wonderful. Yeah. Thank you.
Before I move on to frustration from force majeure, what is very important to keep in mind is that since force majeure is a contractual remedy, for the force majeure clause to be attracted, the preconditions set out in the clause have to be complied with. There are condition precedents that are usually set out, such as a notification requirement, which is usually there's either a time period. Some contracts say within 14 days you must notify. Some contracts say within a reasonable time period. But this notification requirement has been held to be mandatory. There are two judgments of the Appellate Tribunal on Electricity, which have actually gone into this quite well. One of those is Himachal Sorang Power Limited versus CERC. I will circulate the other one. I don't have the name with me right now. These set out the concept as to why this is mandatory. Rationale is this. This is a contractual remedy. You want to take benefit of the contract, you comply with the contract. That's the rationale. Right? Therefore, if you are a lawyer advising a legal officer of a company as to whether to take benefit of a force majeure clause or not, please ensure that condition precedents are met, because ultimately you don't want a scenario where you have missed the bus and the other side comes back and says, well, you can't claim benefit of force majeure because you did not comply with the requirements. Right? Now let me move on to the second limb, which is frustration. Well, I read out, I will be reading out now section 56 of the Contract Act. So I'm an agreement to do an impossible act. An agreement to do an act impossible in itself is void. Contract to do act afterwards becoming impossible or unlawful. This is what is important. A contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promiser could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. Therefore, if I may read this once more slowly, a contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. Therefore, if the contract is to do an impossible act, it is void. If there is an act that later becomes impossible, then also it is void. So in India, this frustration is clearly provided for in the statute. And when it says that the contract becomes void, it automatically means complete discharge from contractual obligations. This is a very crucial distinction. In the case of force majeure, the contract survives. You will have to perform after the force majeure event is over. In a frustration scenario, that's the end of the contract. Right? But keep in mind one aspect. Partial frustration is also possible. I am to further my argument that partial frustration is possible. I refer to some observations in there's one Kerala High Court judgment, and there is in the judgment of Tarapur, the Supreme Court says that where the contract is predicated on a certain factual situation and that factual situation ceases to exist, the contract to that extent becomes otiose, which clearly speaks about a partial frustration situation, right? Now, there's also a Kerala High Court judgment. I'll circulate that. I don't remember the name right now. I'll circulate that, where specifically this concept has been gone into. This is also based on the doctrine of severability, which is recognized in the context of contracts. They call it the blue pencil rule in the context of contracts. We say that if part of the contract is void, rest of it is not void, rest of it must survive if you can sever off the part that is void. Right? Now, when does frustration, in fact, let me give you an instance which I believe would be partial frustration. This is a matter where I've argued it's been reserved, but I think this is a case which would involve partial frustration. So there is a contract for construction. There is a sand source that is available just next to the site. And contractually, at the time of the contract, parties agree that sand will be sourced from here. The other side increases the scope of work drastically, because of which it is not possible to use this sand source because a larger source of sand is required. That source of sand is 180 kilometers away. Therefore, to that extent, the contractual obligation which says that you procure sand from this source would become otiose. And you can then procure sand from that source that is further away and claim transportation charges on the basis of the principle of quantum meruit that I'll be dealing with. Right? Now, frustration would apply more in cases where time is of the essence. So in a situation where for a sale of goods, time is presumed to be of the essence. In a contract for construction, time is not of the essence. Therefore, if a construction project is delayed by 3 months, it does not stand frustrated. Because time is not of the essence. In a 2-year contract, 3 months delay will not frustrate the contract. But if, for instance, masks are to be supplied by March 30th for fighting COVID-19, and the supply of masks are indefinitely delayed because of some restriction that is imposed from importing them, then the contract itself becomes impossible because that timeline of March 30th is critical. In a construction for sale of goods, time is presumed to be of the essence. Therefore, if that timeline becomes impossible to perform because of a frustration event, then Section 56 would be attracted. Therefore, typically you would see doctrine of frustration being attracted in cases where time is of the essence, and force majeure being attracted, obviously subject to there being a clause, where time is not of the essence. Right? Now, let me give you one example of this. The judgment of the Honorable Supreme Court in Satyabrata Ghosh, which is a landmark judgment. It's a very, very crucial case. Yes. So what had happened here, the AIR 1954, Supreme Court 44. The respondent had commenced a land development scheme for sale of plots under which it was obligated to construct roads and drains. The appellant agreed to purchase a plot under the said scheme, and the contract was entered into during the war period. Subsequently, there were certain requisition orders that were passed by the government taking possession of the land for the purpose of the war. The requisition orders were passed after 15 months from the date of entering into the contract, and the respondent had not commenced any work till then. Ultimately, the argument that was made was that because of the requisition of the land by the government, the contract became impossible to perform. The Supreme Court rejected this argument on the basis that the requisition was for a temporary purpose, that for a contract for construction, as was in the fact scenario, time was not of the essence. In such a scenario, the doctrine of frustration and section 56 would not apply. This was perhaps the first and most important judgment of the Indian Supreme Court on section 56. The Supreme Court went on to say, they went on to analyze English law and American law, and they said that since in India we have it codified in a very clear manner in section 56, the English authorities would only be persuasive. Right? Now, there are a few exceptions that are recognized when section 56 will not apply. The first is where the events are contemplated by the parties. So the Supreme Court in Energy Watchdog's case says that where the parties had contemplated acts beyond their control and had incorporated a very wide force majeure clause, then section 56 cannot be attracted, and the only recourse you can take is to the force majeure clause. That's the interplay between force majeure and frustration. So if you have a wide force majeure clause, section 56 will not apply. If you have a narrow specific force majeure clause, maybe it will apply. It's arguable. Right? So in the context of
Anirudh, sorry to bother. Just repeat it because I've received two messages. This subtle distinction between doctrine of frustration and force majeure. What is the basic distinction between the two?
The distinction is this. Number one, frustration discharges the parties completely from the contract. If a contract stands frustrated, they need not perform it at all. Force majeure is a temporary phase where one party cannot hold the other liable. It's a contractual mechanism. So, for instance, if there is a delay of 3 months, which is a force majeure event, then beyond the 3 months, parties must perform.
So it is more akin to, as we say in service matters, one would be, it is a suspension of the act, another would be akin to a dismissal, severance of relationship.
Exactly. Very good example.
For doing it.
Right, so frustration, that's the end of the contract. Right, now the second thing is that in a force majeure, you will have to notify if the clause so provides. Frustration, you need not notify because the contract itself has come to an end. You can even argue for the first time in an arbitration or in a court that the contract has come to an end and succeed. Though obviously, if contemporaneously you've notified, it helps build it because it's ultimately a factual determination. But a force majeure has to be, you have to comply with the strict requirements. Right? Okay, now let me go back to the exceptions. First is events contemplated by the parties. I mentioned Energy Watchdog. The second is where there is substantial performance, where it's merely onerous for one party to perform. Then in such a scenario, a party cannot claim impossibility. See, the best example for this is energy watchdog. So what had happened was that this was a dispute that arose in the context of a power purchase agreement. For the supply of power, one of the supplier was procuring coal from Indonesia. The price of coal from Indonesia shot up. The argument was that I originally contemplated that this would be based on a certain fixed price of coal in Indonesia. Today the price has shot up, therefore the contract becomes impossible to perform. Supreme Court said that this would not be a case of impossibility. Your contract does not say that you will procure coal only from Indonesia. You can go procure from anywhere else in the world. Further, merely because the contract becomes more expensive for you to perform does not make it impossible. This was, therefore, if substantial performance is possible and the circumstances only makes it more onerous, then in such a scenario, doctrine of frustration will not be attracted. The third exception is self-induced frustration, where a party's act has resulted in the frustration event. Let me give you an example. In the context of a power purchase agreement, where there's a captive generation scheme for supplying electricity, the law provides, the Electricity Act, that the consumers and the producer must set up a common entity in which 26% shareholding is held by the consumers. Now, let us assume a scenario where the producer colludes with one of the consumers and tells them, I will buy your shares. So your sharehold, the overall collective shareholding drops below 26% because of this. So overall, all the consumers have 26%. One consumer goes and sells his share to the producer. Therefore, by virtue of an act of the producer, the overall shareholding of the consumers drops below 26%. Then that producer cannot go and take the stand that by virtue of this sale of shares, this is no longer a captive generation scheme. The under law, if you are a captive generation scheme in the context of supplying electricity, there are some benefits that are given. There are some charges that you don't have to pay the government. So it's cheaper to procure electricity this way. Here, a party, by virtue of its own act, brings about a scenario where where it ceases to be a captive generating scheme. In such a scenario, the frustration is self-induced and a party cannot claim benefit of Section 56. There is a judgment of the Madras High Court in TVS versus RK Energy, which sets out the law on this in great detail. Right? So these are the regular exceptions. I think it's 12 o'clock, but I'll take another 5-10 minutes and then I will.
As we often say in all these sessions, we are not playing a 50-over match or a 20-over match that it has to be completed in that case. We don't have the upper cap. As long as the participants are enjoying, they are not captivated participants. They are all voluntary. Okay. If they feel that they have to go by 12:30, they are free. It's not a locked auditorium that nobody can go outside.
Okay, sure. Then let me just, okay. So therefore, there are 3 exceptions. Sometimes it's categorized as 4 because substantial performance and onerous obligations sometimes are split up. So you have events that are contemplated by the parties, you have self-induced frustration, you have substantial performance, and you have onerous obligation. These are the 4 exceptions to frustration. Right? So let me then come to what is the effect of frustration. Right? There are some remedies that follow if a contract stands frustrated. The first is the remedy to claim damages. this is in a very specific scenario provided in section 56 itself. Let me read out the third paragraph of section 56 that I did not earlier read. Compensation for loss through non-performance of act known to be impossible or unlawful. Where one person has promised to do something which he knew or with reasonable diligence might have known, and which the promisee did not know to be impossible or unlawful, such promisor must make compensation to such promisee for any loss which such promisee sustains through the non-performance of the promise. See, this is a scenario which strictly won't apply in the COVID-19 situation, where one party knew about the impossibility, yet entered into the contract. That party will have to pay compensation to the other party. I'm not going to delve too much into this because that is beyond the topic for today, because in the COVID-19 scenario, this won't arise. Maybe we can, where in the COVID-19 scenario, you can, thing is where the government has passed some order, a foreign party is not aware of that order, and then the government enters into a contract contrary to its own order. But these are going to be very like one-off cases. So I won't spend too much time on this. But the more crucial remedy that opens up upon a contract being frustrated is the remedy of restitution. Right? Before I go into the details, let me conceptually explain the difference between restitution and damages. Right? Let me give an example. I enter into an agreement with Mr. Vikas to purchase for him to purchase certain goods, some cotton from me. He pays an advance. Thereafter, I take the advance. What I do with the advance is I go and invest in shares of a company. And thereafter, I don't perform, I just keep the advance. Right? In such a scenario, the loss caused to Mr. Vikas is the advance. The advance is 100 rupees. The loss caused to Mr. Vikas is 100 rupees. If he is going to sue me for damages or compensation, he will sue for the compensation for the loss caused. Therefore, he'll sue for the 100 rupees. But let us assume I use that 100 rupees to purchase shares and the value of those shares goes up to 1000 rupees. My unjust enrichment is not just 100 rupees today. It is the actual value of the shares as of today. Right? So, in a lot of situations, the loss caused may be equivalent to the gain. Where if I don't invest it in shares, I just keep the 100 rupees. Mr. Vikas's loss is going to be equivalent to my gain. Therefore, whether you claim for compensation or whether you claim for restitution, the amount will be the same. But in a scenario like in the example I've given, I use the 100 rupees given by Mr. Vikas, I buy shares, those shares shoot up in value and become 1000 rupees. My enrichment is the value of the shares today. Restitution is a remedy by which you claim the refund for unjust enrichment. The rationale is, I cannot be enriched by virtue of my dishonesty. By virtue of my unjust act, I cannot be enriched. Therefore, I must be forced to repay whatever enrichment I have got to you. Right? So, in a claim for compensation or damages, which is common, you go after the loss. In a claim for restitution for unjust enrichment, you go after the gain. Right? So I can give you an example of a current case. This is only to conceptually explain what is restitution before I go into how it will apply in this scenario. An example I can give you is there was a case which we are currently handling where an advance was given of 10 crores for purchasing shares in my name. But the other party purchased shares in his own name. Today that company has become a huge company where the value of those shares is not 10 crores but 100 crores. We are going after the 100 crores today on the basis of restitution. If you're going on the basis of, not on the basis of restitution, but if you're going on the basis of compensation for loss, I can only claim 10 crores plus interest. That's the difference between restitution and compensation for damages. When it comes to restitution, now the one crucial aspect is that for restitution for unjust enrichment, the contract cannot remain. What happens when a contract stands frustrated? The contract stands discharged. Contract no longer exists. Therefore, the bar for claiming restitutionary remedies is lifted. Therefore, there are multiple kinds of restitutionary remedies, some of which are recognized in the Indian Contract Act itself, some of which are based on common law. The first kind is recognized in Section 65 of the Contract Act. Obligation of person who has received advantage under void agreement or contract that becomes void. When an agreement is discovered to be void, or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. So I enter into a contract with a party in China for me to purchase some non-essential goods. I pay an advance of 1 lakh rupees. Thereafter, COVID-19 hits. Therefore, this contract becomes impossible to perform. In such a scenario, I am entitled to refund of the benefit that I have given him, which is the 1 lakh rupees that I have given as advance. That is what Section 65 says. The second statutorily recognized remedy is that of quantum meruit. Obligation of person enjoying benefit of non-gratuitous act. Where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. Now, let's come back to the example that I earlier gave. I am supposed to procure sand for my project from a source that is next to the project. Therefore, there is no transportation cost. But because of the fact that the contract value increases so drastically and so much of extra sand is required, this portion of the contract becomes impossible to perform. I no longer can procure from next to the site. I have to go 180 kilometers away. In such a scenario, using the rationale of Tarapur's case, the contract to that extent becomes otiose. That contract goes, I then go, but I still perform. I go and procure sand from 180 kilometers away. I spend 10 lakh rupees transporting all of this sand. Now I can claim this 10 lakh rupees as quantum meruit because there is no longer any contract in relation to this. Therefore, the restitutionary remedy opens up. Secondly, I never intended to transport it free of cost. If I never intended to transport it free of cost, you must pay me for it. That's the principle. The third kind of remedy is a common law remedy. So far as the common law remedy is concerned, you can actually, the remedy I'm referring to here is a remedy of tracing. So in the example that I gave of me entering into a contract with a Chinese company and paying an advance, if I can show that using that money that Chinese company invested in that 1% shares of HDFC, using the advance that I paid, then instead of going and claiming the money back, I can ask for transfer of those shares to me. That's the equitable remedy of tracing. So that's the third kind of restitutionary remedy. So I think I'm a little beyond time, but what I will do is briefly, because I think Vikas specifically mentioned to me that there was some interest in relation to lease agreements. So I will deal with that.
Lease as well as we can, two generic questions I will ask, since we are already barged with so many questions on the chat box. Yeah. And I'm making it clear that my screen is showing us 29 messages. We will not take any more questions because we are already running out of time. Two questions for lease and this rent, which is generic in nature, and as to whether it would be the mandate that what the government has said that you have to make the salaries, etc. during all this time, the government's order to that effect.
Yeah, insofar as lease is concerned, the position is that
lease as well as both.
Yeah, so the judgment in Raja Dhruv Dev versus some Raja Singh, there's a Supreme Court judgment which says that a lease agreement would not stand frustrated unless the lease property itself stands destroyed. That would only be the ground for frustration. A mere delay or mere fact that a party is not able to actively use the rented premises will not result in an act of frustration. Specifically in the context of an epidemic situation, there is a case in Hong Kong called Lee Chin Wing versus Zhuan Yi Xiong, which arose in the context of the SARS epidemic. So there was a contract that needed to be, there was a 1-year lease agreement, maybe 2 years, I'm not sure of the period. 3 months a party said that they could not pay rent, and they claimed that this resulted in frustration of the contract. The courts in Hong Kong said that merely 3 months in a 2-year contract is hardly anything. If you can say that, okay, 3 months in a 3 months contract or 3 months in a 6 month contract, maybe you can make an argument for frustration. But generally in a lease agreement, it will be very difficult to argue frustration unless say for instance, if the government acquires the leased property itself in order to then provide beds for COVID-19 treatment, then you can argue it, but not just because of the difficulty it causes because you can't use it. Frustration, you can't argue. Force majeure is obviously dependent on the scope of the clause. Most force majeure clauses that I've seen in lease agreement also bring in this condition of destruction of the property or inability to use the property. Now, inability to use the property, you could argue in a situation where you can say that the property is completely inaccessible, I could not have used it at all. But if you're living in the property, then you can't claim it. Or if you haven't, if the property is still accessible to you, then you can't claim it. Yeah. Then sorry, what was the second question? On payment of wages.
These orders issued by MHA that you have to pay salaries to the employees irrespective of the fact that you're not working with the companies, etc.
Now, insofar as salaries are concerned, again, I think I don't think they're subject to correction. They're only advisories, right?
They are primarily advisory, but be that as it may, people are still getting a hunch on that. If we go on the website, this Jay Sagar and all have also posted their Q&A on the websites.
So again, see, this is not certainly this will not this will not result in a frustration scenario.
So whether you could terminate or you could lay off or retrench, what would be the parameter?
Now you need to look at the terms of the contract, look at the terms of the force majeure event in your employment contract if you have any. In my view, this will not amount to a frustration of a employment agreement. Certainly not a frustration. Well, if this continues over 7-8 months, then maybe yes, but not lockdown for the period that we have currently had, or even if it's going to be 1 or 2 more months. But certainly not a frustration, according to me. But insofar as force majeure is concerned, it depends on the terms of the force majeure clause itself. The only rationale that I can think is, can you then say that this is compensation for the work that you are doing? And since you are not actually doing any work, that I need not pay you compensation. That's the only argument I can think of. But that also you must be able to show that it is impossible for them to do any work during this period. There are a lot of services that can be provided, that you can work from home and continue to do work. Only if it can be shown that the nature is such that no work can be done, then such an argument will come in. But it's impossible to give an argument in black and white for this, because all of these are very dependent on the terms of the employment agreement. So I don't think it is possible to give a general advisory on whether you should pay salaries, whether one is you're morally obliged to pay, but whether you're legally obliged to pay or not depends on the terms of the employment agreement. So that's not something I can answer in black and white.
So we start the Q&A session.
Yeah.
I would be reading the questions because we have received on the chat box.
Sure.
Just hold on. Mr. Juhi Gupta asks, what if there is a delay in giving the notice? For example, if a contractor was not able to do work because of the first lockdown, but didn't invoke the force majeure clause, thinking that the lockdown in 3 weeks would be over?
Okay, see, if there's a delay, going by the judgments, this timeline is mandatory. But what you can then claim is, for instance, if you have to give a 15-day notice, you give the notice after 17 days, right? So the way you can then take it is 15 days from the date of the notice, like 15 days, that's your cover. So therefore, for the first 2 days, then you can't claim, but the balance you can claim.
And Sumit Saha asks, can COVID-19 be a kind described as a force majeure clause?
Yes, a lot of these clauses would cover it, specifically in the context of, I read out some of the force majeure. I read out the railways GCC, which specifically covers an epidemic. There are some other general force majeure clauses that are also broad enough, because this is certainly something that is beyond the control of parties. So it's obviously clause specific, but most force majeure clauses would cover it.
Okay. Suraj Ramachandran asks, irrespective of the contractual terms, whether the employer, being a government entity, can force the contract under the garb of the scenario to renegotiate the terms of the contract, which may not be viable for the contract, whether the government entity can go for rebidding of the contract.
No, they can only do so if they see. Okay, we have to split this. There are two different scenarios. The first scenario is a case of frustration, and the second is a case of force majeure. If the contract stands frustrated, they can go ahead and do so, because there is no contract anymore, right? So then they can renegotiate the terms, or they can rebid, but this will have to be in a scenario where only in a scenario of frustration. This would usually be in a contract, say for sale of goods, where time is of the essence. This would usually not be the case for a power purchase agreement or a construction and infrastructure contract, where time is not of the essence. But in a case where it's only a force majeure that is attracted, rebidding or renegotiation is impermissible.
Jasween Kaur asks, what happens to the implementation of the approved resolution plans under the IBC, especially if such resolution plan does not have a force majeure clause?
Well, very interesting question. If it does not have a force majeure clause, then the only thing you can come under is frustration, right? Again, I've set out the very high thresholds. So usually a resolution plan is over a extended period of time. It's not something that is done in 3 months, 4 months. There may be some payment obligations that kick in immediately, but the implementation itself is over a longer period. Therefore, in my view, it's highly unlikely that in such a plan, time would be of the essence. If time is not of the essence, then it is unlikely that the doctrine of frustration would be incorporated. would be attracted.
And then Sumit Saha asks, where COVID-19 epidemic is not specified in the FM clause, can COVID-19 be described of the kind described in FM clause dealing with the natural catastrophes such as earthquakes, volcanoes, activity, etc. be considered?
Well, it really depends on the wording of the clause. If the wording is restricted to earthquake, volcanic, hurricane or typhoon, then no, because Supreme Court has said it has to be narrowly construed. But usually it will be much wider than this. Most force majeure clauses that I've come across would say that if it is because of events not attributable to the parties and beyond their contemplation, including events such as this, but not limited to this, then such a force majeure clause would cover it. So it's really dependent on the force majeure clause in a particular contract. But yeah, just what you have extracted would not cover it.
Again, we are repeating it that we will not be taking more questions since the last question was 27. I've already seen that 13 more have barged in. Amarjeet Virk asks, consequences if there is no such clause like force majeure in the contract, especially in the scenario like COVID-19, can it still be invoked under the contract jurisdiction?
No, so if there is no force majeure clause, you will have to only go for frustration if you meet the high threshold of frustration. Otherwise, you can't claim force majeure in the absence of a contractual clause to them.
Just asks, if the lease deed has expired few months back and tenant is paying rent to the landlord without any lease deed in place and tenant was due to give possession on 31st March and unable to hand over the possession of the premise due to the lockdown, can landlord still claim rent and forcibly control the restaurant?
Well, it depends. If the tenant is still staying on in the premises, then
premises can be legal till the rent is not paid.
I know if the tenant is continuing to stay on in the premises even after March 31st, that would again, because this would not be a case where there would be a tenancy under the agreement, but tenancy based on holding over. So that would continue on a month-on-month basis if he continues to stay there. If he decides to surrender possession and leave, then he can't be forced to pay rent going forward. But if he continues to use the premises, then yes.
Karun Aditya asks, can COVID-19 fall under the natural consequences if the same has been provided for in the contract?
Yes, it can.
Vigneshwar Walia asks, what about these clauses in the health insurance contracts to deny hospitalization claims?
I have actually not had the occasion to analyze these clauses in a health insurance contract. So I'm not at this point aware of the scope of the clause in a health insurance contract. I think I'll have to look at the individual terms before I can answer this question. If you have a clause available with you, you can share it now. I can look into it and answer the question.
Or you can share it on the WhatsApp. I will share it with you.
Yeah, you can even WhatsApp it to me or email it to me.
A friend of mine, I will revert to him. Yeah. Or I will thereafter post it in the group itself.
Sure.
Just ask, if any tenant who has to take the possession in some other premises, and as per lease deed, the possession was to be given in the month of April. As the possession is not given, then can only the tenant ask for the refund of the security which was paid in the advance?
No, because there is already a contract in force. That contract does not stand frustrated. I refer to that Hong Kong judgment, which I think would be applicable, and I refer to the Supreme Court judgment in Raja Dhruv Dev's case, which talks about when a tenancy agreement stands frustrated. So, if in the absence of frustration, the contractual obligation would continue, which means security deposit should remain and should be refunded only in terms of the contract, which would usually be only at the end of the tenancy.
This person has not posted the name, but otherwise asks, is it necessary to have a force majeure clause in the contract? Can't it be implied on the basis of just/reasonable or equity? Isn't this obvious that most of the contracts can't be executed right now?
Well, no, it has to be specifically included in the contract. If you're going to be arguing an implied term, it's almost impossible to argue because there's a Supreme Court judgment on when you can read an implied term in Nabha Power's case. And they set out a 5-stage test in that, which is going to be very, very hard to meet. This is especially so because there is already a statutory remedy of frustration that is provided. Therefore, if there is no force majeure, you will have to meet that high threshold of frustration. Because the intention of the parties is that if they are to bring down the threshold for claiming that they need not perform, at least for some period, then they would specifically be providing a term in the contract to that effect. It would be very difficult to read an implied term, especially considering the judgment in Nabha Power.
Sonia Madan asks, can COVID-19 pandemic be included under this expression? Act of God. Do organizations need to review force majeure clause in contract and execute amendments in the contract? What amendments can be considered to cover over the liabilities and rights during the COVID-19 pandemic?
See, as I said, most force majeure clauses that I've seen are wide enough to cover it. Because even if they don't expressly mention pandemic or epidemic or lockdown, they are wide enough to cover it. Most that I've seen, except a few in some lease agreements that talk about destruction of the property. But therefore, I don't think there would be a requirement. But obviously, if in a given fact scenario, if the clause is narrow, then you may have to renegotiate it.
Then Hari asks, in a FIDIC contract, epidemic is not expressly used, but it may fall under any of the four conditions stated in clause 19, force majeure, whereas said epidemic is expressly used in 8.4d. Isn't this a correct statement to state that the parties have specifically agreed that the circumstances of the epidemic is not considered as a force majeure, as this would be dealt in accordance with 8.4 and 20.1 of the contract, which has been expressly agreed by the parties, that is time and cost impact?
Subject to my memory, FIDIC clause sets out four conditions. Let me try and open it right now. Subject to my memory, it sets out four conditions that are broad enough to cover COVID-19. Let me just see if I have it before me. Just give me 1 minute. Yeah, I have the version in the 1999 edition, Red Book, before me. Let me just read it out. In this clause, force majeure means an exceptional event or circumstance, A, which is beyond a party's control. COVID-19 would meet this, lockdown would meet this. B, which such party could not reasonably have provided against before entering into the contract. I believe this also would be met. C, which having arisen, such party could not reasonably have avoided or overcome. I agree, again think we would meet this criteria. And D, which is not substantially attributable to the other party. We'll meet this as well. Therefore, this would be covered, but then it says force majeure may include, but is not limited to, exceptional events or circumstances of the kind listed below, so long as conditions A to D above are satisfied. The war, hostilities won't come under that. Rebellion, terrorism, revolution, insurrection won't come under that. Riot, commotion, disorder, strike or lockout will not come under that. Munitions of war, explosive materials, radioactivity, so on and so won't come under this. Natural catastrophes won't come under this. But therefore, it's important to read there are 5 instances given in 19.1 of the FIDIC, which will all be covered, but this is qualified by the statement saying that this is not exhaustive. That so long as the 4-step test is satisfied under clause 19.1, it would be a force majeure event, even if it does not come under the 5 categories that are set out below 19.1d. In such a scenario, I believe that the 4-step test is likely to be met because it's wide enough to cover a COVID-19 scenario. I don't have, Now, I don't have 8.4D before me. But for your answer as to whether this will be covered by 19.1, I believe it will be covered by 19.1. On the issue of, I don't have 8.4 and 20.1 before me, but subject to memory, 20.1 deals with the scenario of contemporaneously notifying a claim. That may not apply here because you're not going to have a claim arising out of the force majeure clause. You will only have to notify them under 19.2. 19.2. You will have to issue a notice within 14 days to the other party that in fact 19.1 has been attracted. That is, if you're claiming under the force majeure clause. In the context of 20.1, that will come only when you're making a contemporaneous claim. That has to be, I think, subject, there's a time period set out within which it has to be done. But even on this, in the Indian context, 20.1 of the FIDIC may not be valid as it is contrary to section 28 of the Contract Act, because it says that if you don't make that within that specified period, the claim stands extinguished. That is contrary to section 28 of the Contract Act. So, yeah, 8.4, I'm not in a position to tell you because I don't have it before me right now and I don't recall what it says.
Sonia Madan has another question which says, a contractual dispute arising for a delay in a performance of a contract, where period affected on account of COVID-19 is one of the causes for delay in performance. Holding the affected period as force majeure, will it also enable saving clause of the employer to pay interest and cost for the affected period to contractor in the awarded amount?
Interest it won't. Interest will certainly have to be paid because if there is some money that is due before that, then interest on that money will be earned by the employer by keeping that money in the bank. There's a 5-judge bench, old judgment in the context of section 34 of the CPC which says this. Right now, I don't recall the name. I'll circulate it. It's a full. It relies on a case called G.C. Roy's case and then sets out some principles on interest. So, insofar as interest, it will certain the employer, if they're sitting on the principal and then they themselves are earning interest, cannot escape from liability. Insofar as costs are concerned, again, it will depend on what is the real cause for the delay. Is the real cause for the delay the force majeure event, or is it some other prior breach? Like in the example that I gave, if the site itself has not been handed over, then the real cause for the delay is site being handed over, right? Or if the design obligation is on the contractor and the contractor has not even submitted a design, then the real cause for the delay will be the design being submitted late and not the force majeure event. So in such a scenario, subject to the terms of the contract, certainly a claim for compensation can be made. But again, it's a very factual test. So you will have to carry out your delay analysis. You will see you will have to analyze what is the dominant cause for the delay. You will have to look at it on a case-to-case basis. And if you can show that the dominant cause for the delay is not the force majeure event, but a breach of the other party, then compensation can still be claimed.
Muthu has posed a question. In case of a construction contract, there is extension of time given due to the default of employer, not able to acquire land. Can contractor claim compensation for fixed overheads during the extension of COVID-19?
Yeah, no, I expressly dealt with this because in such a scenario, the dominant cause is not COVID-19 but not handing over land. So, such a scenario, claim for compensation can be made. Of course, there are a lot of contracts that say that for delay in handing over a site, no delay damages are payable. That's a topic by itself because there are lots of judgments of the Supreme Court which carve out exceptions. So those are all independent of this. But does COVID-19 force majeure situation come in the way? In the fact situation that you provided me, the answer is no.
Byapu Rapu says, what is the remedy available for the contractor If the client rejects the contractor's submissions for compensation, can contractor approach arbitration or court if client rejects contractor submission under force majeure or suspension due to COVID-19?
Yeah, it's dependent on if there's an arbitration clause, then you go for arbitration. If there's no arbitration clause, you'll have to approach a court. Determination will have to be by the body, unless there's some other specialized body that's been set up that has to determine that issue. Like for instance, sometimes there's a chief engineer is given certain powers to decide on a particular issue. That is whether it's an accepted matter or not. So if it has to first be submitted to the chief engineer, you need to follow the contractual mechanism. But of course, if the chief engineer rejects, you can then go to court.
Then what are the exceptions to the force majeure? Please explain in brief in context to the lockdown.
Yeah, so I gave 3 exceptions where a claim can still be made during my lecture. First was causation, and in fact, first and second, 2 types of causation examples that I gave. And the third was where there are other clauses like a change in law clause or a suspension clause. These are the exceptions that where you can still make a claim, notwithstanding the fact that there is a force majeure event.
Then Dr. Sangwan asked, can we delve on the topic of effect of COVID-19 on leases where there exists a commercial lease of a restaurant and the government has directed closure of business activity? Will the lessor be liable to pay the lease amount to the lessee?
No, my view is that this will not result in frustration of the lease agreement. I've already given some examples, some case laws for this. In the context of a lease, therefore, there will not be frustration. There may be a force majeure scenario based on the terms of the force majeure clause. Now, as I mentioned, in a lot of the force majeure clause that I've come across in lease agreements, it refers only to unusability of the property itself, right? So here the commercial purpose behind the lease may not be relevant because that may be the difference between a lease and a license. In a lease, the compensation is paid for actually handing over possession and giving possessory rights to the other party. In a license, you give it for a specific purpose. Therefore, if it is not a restaurant that is leased out, but is only licensed for running the restaurant, then the situation may be different.
Then Suraj Ramachandran asks, LOA issued in a contract being before the COVID prohibition within timeline of execution of the contract in a timeline of 3 weeks, which is in fact during the lockdown. Now, assuming we execute the contract, are we entitled to any extension of time for any of our obligations on a later date basis of the COVID-19 scenario?
The LOA is before COVID. Well, let me just go through. The LOA is issued before the COVID prohibition within a timeline the next 3 weeks, which is in fact during the lockdown. Assuming we execute entitled to any extension of time. Yes, usually in a construction contract, I presume this is a construction contract. In a construction contract, time is not of the essence. If time is not of the essence, the contract would not stand frustrated. If the contract does not stand frustrated, then whether or not you are entitled to, usually there would be a force majeure which would be attracted, in which case you are entitled to an extension of time. But if the contract is not a construction contract, but is a contract for, say, supply of goods where time is of the essence, then there's no question of extension. The contract just stands frustrated.
He has not named his name on this thing. He asks how a principal employer becomes responsible for payment of wages in construction contracts in the given scenario, in the present scenario.
No, it depends. Again, this is very difficult to give a black and white because it depends on the terms of the agreement. I don't know whether you're looking at payment of wages to laborers, whether they are contractual laborers, whether they are staff that are actually hired by the company. If they are staff hired by the company, it's dependent on the terms of the contract with them as to whether you can then bring in a force majeure obligation or whether you can bring in the obligation of saying that since you're not doing any work, I don't have to pay. All of it depends. See, let me give you an example. If in the terms of the contract, it's made very clear that payment is only upon them doing certain kinds of work, then payment need not be made. So it's very difficult to answer this question in vacuum without the specific terms of the contract.
Then what if the contract is silent on the cost part and the force majeure clause? Will it be beneficial to claim it under clause 20.1 of the contract's claim?
Where is this? Sorry.
It's written at 3300. Again, we are requesting that you actually post the name. After Ankit Dhingra, then the question is asked by 3300.
I'm not able to.
Can you see the cursor?
I am not able to see this question. 1 second.
It was posted at 12:27.
This is by Ankit. No, after Ankit Dhingra.
After Ankit.
The government has inserted force majeure. That's no.
No. What if the contract is silent on the cost part in a force majeure clause? Will it be beneficial to claim it under clause 20.1?
If the contract is silent, then well, whether you're going to be able to make a claim or not is dependent on the other breaches. So if you can show that there were other breaches by the other side, then you will have to make the claim under 20.1 contractor's claim.
Then Mr. Sachdeva says, government has inserted the force majeure clause in all the loan agreements by implication by excluding the period of default from the period of default for declaration of NP.
1 second, I'm just trying to. Where is this question?
I've skipped 2, 3 because the rest were only praising you.
Oh, okay.
That was a praise.
I'm sorry, 1 second. This is
posted at 12:27 by VK Sachdeva. Just before a question prior to Raghujit Madan.
There would not be any frustration of sorry.
No, government has inserted the force majeure clause in all the loan documents by implication, by excluding the period of default from the period of default for declaration.
Yes. That's a comment, I think. The government has now extended the saying that there won't be any defaults during this period.
And then Raghujit Madan asks, certain legislations provide remedy of statutory arbitration for certain infrastructure projects where there are no formal contracts such as NHI, and thus no force majeure clause. How the affected period be treated under such statutory arbitrations to save the government from the liability of cost, interest, and expenses?
No, the statutory arbitration is just the forum. The forum will have to apply the principles of law on this, which I have just discussed. I don't know whether the question is on whether if there's a delay in approaching the forum, what happens. On that, the Supreme Court has extended limitation across statutes for all fora. So if the question is on the time, on the inability to approach the forum within the specified time, that stands extended by virtue of the Supreme Court order under Article 142. If the question is on what is it that fora will apply, I set out the principles of law during my discussion today, and that statutory arbitral tribunal will have to adopt the principles that I have just discussed.
Now questions have been posed by R&S. It says, in the absence of integration clause, can FM clause be inferred from the intention of the parties and their prior correspondence?
What is an integration clause?
In the absence of the integration clause, can FM clause be inferred from the intention of the parties and their prior correspondence?
So, because from what I understand, there's no FM force majeure clause in the contract, but the earlier pre-contractual correspondence seems to indicate that they should have one. No, the position is that when there is a conflict between the terms of the contract and pre-contractual negotiations, the terms of the contract will prevail. The only time when you can go into pre-contractual negotiation is when there is an ambiguity in the clause to understand how that clause must be construed. Therefore, if parties were negotiating a force majeure clause and ultimately it is not there in the contract, you can't go back to the negotiations to reincorporate the force majeure clause.
Though going out of context, certain persons have put in the chat box as to how to be updated regarding when is the next session and how to get the information. Either they can just look into the chat box, we have given the link, or you can like the Facebook page which says Beyond Law CLC. You will come to know the latest updates regarding the ID and meeting ID as well as the password. We are skipping all those questions where the names of the persons are not reflecting. If they don't want to show their name for the questions, we are skipping because we are running out of time. And certain judgments, Anirudh, for your this thing, few of the judgments have already been posted by my office also in the chat box, and rest I will take it from you. Subsequently, you can post it on to me on the WhatsApp. I will post it on my group.
Yeah, in fact, what I will do is, I think most of these judgments with citation I've referred in my articles on Bar and Bench. So I will circulate links to the articles which contain all the citations. Do you think that would be easier? Or if you want, I can individually circulate.
No. Just give me the WhatsApp judgments. We have also asked them on the chat box to give the email IDs, because subsequently I will ask them to, they can connect us on our email. Okay. Sure. IP Singh asks, in case of an OTS with the bank installment due in a lockdown period is not paid, then can bank cancel OTS? What is the remedy with the defaulter?
No, because once there's already an OTS, that itself would have the status of a contract. And in such a contract, time would not be of the essence, because payment obligation, usually time is not of the essence. So usually a delay in that would only mean that the party would also have to pay interest on the amount. But I am not sure whether the general order to banks, I've not read the general order that has been issued to banks on charging of interest. I don't think there is any waiver on interest, which means the only consequence would be that on the OTS sum that became payable during this period, if that payment has not been made, interest would also have to be paid.
We have completed with the section. I'm just looking for Sonia Madam. Probably her connection is not forthcoming. She was to formally announce the vote of thanks.
Okay, no formalities at all.
No, she's there. No formal. Before I ask upon Sonia to say, I will just sum up the entire session. Anirudh, in my own words, I say it's a very enriching session. Even though we have stretched out a time constraint, but still the participants are there and they were quite eager to ask more questions. We would ask from on behalf of our team that we will take further that you should come over for another session on another enriching session on your side. Now, when I saw the participants on when the participants were being entered, I'm just reminding it is just like a mass-based leader, pan-India presence like Narendra Modi, Indira Gandhi of her time. Same way we have got participants pan-India. It was a fantastic session. You see, there were two things. We are all going through the dark days ahead, but the enriching session from your side, it was just like when we say the jasmine gives the best fragrance in the night. It was in the same way. After hearing you, it is enriching to the mind, and in the dark days we are seeing a good fragrance which is worth enjoying it. Over to Sonia. So, Sonia.
Yes, am I audible? Thank you, Vikasji. I am delighted to propose vote of thanks on behalf of Beyond Law team for our distinguished speaker today. I have had the privilege to hear Mr. Krishnan in some conferences before, and like each time, the keynotes of the discussion were so elucidated and absorbing. The law has been reiterated, the law reiterated, several judgments have been simplified. So the lecture definitely helps broaden our perspective. The understanding of today's topic for discussion, in fact, is so pertinent that it is going to be the basis for several contractual disputes that will arise on account of situation under prevailing pandemic. So I would like to express our profound gratitude to Mr. Anirudh Krishnan for an extremely enriching and meaningful session today. Mr. Krishnan, would also like to welcome you sometime in Punjab and Haryana High Court, and thank you all for making it very cordial and smooth.
Thank you very much, Sonia, for the kind words. I'd be happy to come there whenever it's possible to travel. And thank you very much, Mr. Vikas, for inviting me here and providing me this wonderful platform.
It's vice versa. But it is only during these testing times we have been able to connect. Otherwise, probably we would not have been connected. The virtual platform has been able to make us connected. It is just as if I am feeling that you are right back in my office, bang opposite the seat, and we are discussing and we are having a healthy discussion across with large number of friends. It was always a chai pe charcha, but this charcha is without chai.
The silver lining in all of this is that I think technology is being used very fruitfully. Yeah,
we will catch up. For the other viewers and participants, we just wanted to say for the coming this week up till Monday, we have already the participants. Tomorrow, Mr. Patwalia, who is the former judge of Punjab and Haryana High Court and he's a former Additional Solicitor General, he will come. Then on Thursday, we have Pinky Anand, who is Additional Solicitor General of India. Then on Friday, we have Justice Amit Rawal, who has gone from Punjab and Haryana High Court to Kerala. On Saturday, we have Mr. Aman Lekhi, who is Additional Solicitor General of India. Thank you, everyone. Be connected. You can connect on the Facebook page or on the WhatsApp. Thank you, Anirudh. Thank you.
Thank you. Thank you so much.
Thank you.